want to identify what case you're being heard on this motion. Go ahead.
Judge, I filed this motion and on behalf of Mary DeCamp. She's my only client. So I would suggest that this is State of Arizona versus Mary DeCamp.
Okay, and obviously any ruling will probably affect the rest. No, what, they can bring the same motion, right? Right?
Yeah, they can, yeah.
Yeah.
But if you rule correctly, it probably would be persuasive.
And save the city some money.
Joe and I go back a long time. He hasn't changed one bit. So how do you want to proceed? That's your motion.
Judge, I have, I think, probably 4 witnesses that I want to call.
Okay, do you want to make any pre-hearing motions by either one, or any, do you want to make an opening statement? I know it's on trial. Anything, I just start calling witnesses. You may.
Yeah, let me just, not really by way of argument, but sort of summary as to what we're involved with is, I think it's critical for evaluation of a constitutional issue, particularly a First Amendment issue, that we talk about some things, especially since the city has raised some defenses. So what I think these folks hopefully will explain to you is sort of what this Occupy Tucson event and assembly and group is about. What's their message? How are they organized? How's that message transmitted? How's it understood by the public? Why? Because the city is trying to assert a rule that says, boom, at 10:30 at night, you can't be there until 6 in the morning. Why that's useful and effective for the organization. You know, that sort of stuff, because the First Amendment issues relate to the message that's going out to the public. Is the public receiving the message, and why are they doing it, and how they organize? Because authentic First Amendment expression, authentic assembly has an important role. Obviously, that's at the top of the list with our.
I'll interrupt you, Bill. Is this particular case for the court to determine more on the assembly side rather than limiting any speech at all?
Well, I
understand they probably go together in that particular case. I mean, you assemble and have speech and express yourself, whatever your feelings are and your beliefs. But with the regulation of the park, is the issue, the big issue, does the city have the authority, either safety, health, and welfare, or some sort of issue, to restrict the use of the park for certain times with reasonable notice and legitimate legal reasons? Isn't that the issue?
No.
Okay.
That's
Go right ahead.
you know, that's not the issue.
Okay.
And the reason that one of the reasons why that's not the issue is if you take a look at the city ordinance, which is attached to the motion to response to the city. They've attached the ordinance, and they've attached some minutes of what happened at the mayor and council meeting. And everything in that ordinance relates to, if you look at the kind of events that happen in the park, they relate to picnics in the park, serving beer in the park, certain entertainment, all that kind of stuff. There's absolutely nothing in there that relates to political uses or political expression. Well, yeah, because they, you know, all all these cases will talk about how if it affects your First Amendment rights and assemblies, you have to narrowly draw the statute. They use the term narrowly tailored. So my argument is, this thing isn't tailored, let alone narrow. What they've done is, my analogy, it'd be like sometimes maybe the government says, here's a drug you can use for this disease. And then somebody else is prescribing, trying to use it for something totally different. They've created some rules for a variety of uses in the park, but none of them relate to or at all to political activity. And they rely, for instance, on this Clark case with the U.S. Supreme Court and the National Mall, and the park's got a bunch of rules that all relate to politics. They're in fact narrowly drawn because they have demonstrations there all the time. So I think it isn't an issue of like, could the city draw up ordinances in the park that relate to certain political uses that are narrowly tailored that can affect First Amendment rights and stuff? Because I actually don't think they've done it in this case. One of the witnesses, I think, can tell you that Dick Kaiser was participating with the Occupy group and the city where they were trying to frame an ordinance that would deal with this sort of thing, deal with political activities in the park. This one is blind to it. That's why it's a little bit of a different issue than you might have perceived.
Okay, thank you. Alan, do you want to address the question?
Yes, Your Honor, I do, just briefly. Your Honor, if you could accept Mr. Risner's reasoning, then the city doesn't have any authority to regulate any activity in the park. Any special interest group that wants to come forward could make exactly the same arguments that Mr. Risner is making, in that my particular activity is not envisioned by these ordinances. And it's telling that he says that these are blind to political considerations. That's exactly right, Judge. They are blind. They are strictly content neutral. Mr. Risner and his group and the Occupy Tucson people and Mary DeCamp want to substitute their judgment for the best way to administer the parks in the city of Tucson for the people that are charged with that administration of the parks. They believe that they should be allowed to do whatever they want to do, and that does not benefit the common good that they insist on. When they come in and they occupy the parks during the closed hours, that's in contravention of the ordinance, and there are certain provisions in the care and the maintaining and the aesthetic value of the parks that requires a certain amount of rest, if you will. In addition, we will submit to the court that the witnesses that Mr. Risner proposes calling, it seems to me that this is a legal issue for the court to decide. Does the First Amendment trump the ordinance of the city? That's basically it. So if you're going to allow the testimony from the witnesses, Your Honor, I would ask that you would place a time limit on them, something reasonable. I'm not trying to silence them, but perhaps we could limit the amount of time we're going to spend. Thank you.
I have no problem with that.
Well, no, Judge, I certainly will attempt to focus on the issues before the court. I don't have any other testimony to offer, Judge.
Okay, now we'll go back then. I guess it's your motion, yours, party of the motion some more, sir.
Yeah.
Go ahead. Yes, sir.
I think there's any of us probably that aren't aware of some really major issues facing the country, if not, the planet. There's phenomenal economic problems that the country's having. Unemployment's a huge problem. You have different solutions as to how to how to get there, but we would all recognize that that's a big problem. In Tucson, you can't be blind to the fact that global warming is going to affect us. That's a major problem. You can't be in this city and not be aware of the problems of the foreclosures and so forth. These are issues that generally are affecting the public. And in our democratic system, people need to be able to come together and to discuss issues, to talk to their neighbors, to organize, to get messages out. And, you know, it's in the Arizona Constitution, we actually kind of break up the free speech and assembly. We have Section 5 of our rights in Arizona is that the right of petition and of the people peaceably to assemble for the common good shall never be abridged. It's part of our Constitution in Arizona that all of the political power is inherent in the people and governments there to serve the people. It's part of our Constitution that the provisions are mandatory in our Constitution. So there really, if society is to progress, if society is to deal with the issues and to do so in a peaceable community manner, we've made a decision. And our decision is that among our most important rights is the ability to speak freely, the ability to discuss ideas, and the right to assemble for those purposes. So we have here a kind of a hierarchy. The hierarchy in our system is that the people have these rights, and then our Constitution puts those rights in big letters. You've got the right to assemble. You've got the right to freedom of speech. And to exercise those rights, where do you do it? The cases are clear. We all know that the penultimate area for assembling and exercising rights are public spaces. You know, maybe you can have a meeting down at the Unisource Tower, but then they tell you to leave. You know, the streets are public, but that's not quite so useful for your teach-ins and your organizing and stuff. So really, parks are the place where it's best suited and has historically been used and is best suited for the assembly and exercise of political rights. Now, the city has asked some questions like maybe was there somebody that wanted to use a park that didn't and stuff. But they've offered no evidence. They've offered no evidence of interference with the public, actually with the park, a group that wasn't able to use the park, a failure to accommodate other needs with the park, damage to the park. They've offered absolutely none of that evidence. So what we have is a city ordinance that, I don't know how easy it will be for me to dig it out, but this city ordinance, when you look at it, Judge, everything in there that it's related to, as I said before, there'll be rules they have on if you want to have a rodeo here, you want to have your sell beer in the park, you want to do this and that, they've got rules for that. They're here, and I don't know if I think you may even be able to take some judicial notice of this. But it's sort of an interesting thing to me that, like for instance, Dick Kaiser talked about how his case had been dismissed. There were some 200 cases or more that have been dismissed from Armory Park. And it's
Isn't that because of lack of notice?
lack of signs up, yeah. So it's kind of interesting to me where, you know, the city comes in and they say, well, you know, this is content neutral, these rules. Well, that's true in the sense that what they're suggesting is it violates everyone's political rights in that park, regardless of what it may be. And they gave a couple of hundred tickets for violating an ordinance that said there needs to be a sign posted even when there wasn't a sign posted. So to me, that's kind of a reflective of it's kind of like a motive where they're hostile to the political expression, hostile to free speech, which is pretty normal with government, but I think that's a bit of what we're seeing there. But in any event, we have the biggest and the most important of our rights that are most useful for the public to be able to assemble for the common good. And the city has a 1030 rule that they've offered no evidence as to the purpose of the utility of that rule. On the other hand, the Occupy people, it's part of the message, it's part of the success of the group to be able to say, look, we're occupying this space. There's issues that aren't being addressed on the agenda nationally and locally, issues that are important to the community and the people that we want discussed, and we want those issues addressed, and we want to be in a public space that's prominent where it can be seen what we're doing so that our message can get out. And we've shown that they have a message that is getting out. The public perceives, the public understands what the Occupy group is about. The public understands when they come in, you have actual evidence of it when they come in and they're giving contributions to it. People stop by and say, we can't be here all the time, but we're supporting of you. We have thousands of people on the Facebook that say, we're following, we're friending you, we're watching what's going on. So really, we have an important, needed, successful, communicative political movement where a group of people are assembling for the common good. And absolutely, this kind of activity must be supported by the courts. The oath you and I took as a lawyer, all of us, is to support the Constitution, support the right of the people, give room to breathe so that the political expression and the discussion of issues can go on. And on the other side of that, we have nothing that is in front of you except in an ordinance dealing with other stuff, somebody says 1030's the limit. And that deference to that small little rule cannot override the social importance and the high level of the Constitution and political rights that are involved. Thanks, Judge.
Let me ask this question on the ordinance, Will. The ordinance itself has punishment at the end, the 6-month deal. In fact, it says in there that the rangers can eject certain people if they violate what's in there. I'm talking about politics right now. But, for instance, they in swimming, they visit areas. If they don't do it, they can eject them.
Yeah.
You don't have any problem if somebody does puts a huge battleship on a pond out there that could be stopped by the police, for instance. I mean, these are, you have no problem with these being legislated by the city that's in here. I'm not talking about your case.
No, I don't have a problem with that. I understand that it's in the public interest to have, park rules. I understand that.
This does not prohibit politicizing in a park, does it?
No.
Except by the 1030. You can go politic and you have free speech and you can assemble at any park at any time for like 16 hours a day.
That's absolutely correct.
It's the 8 hours that bothers you, the folks here.
It is the 8 hours that bothers us.
Yeah.
And the reason is because that really affects the effectiveness of the group. It affects the message of we're occupying here because these are issues that need to be dealt with. It affects the number of people that are involved with it. It affects activities that are useful to the group that occurs later at night. So in fact, it's the 24-hour occupation is an important part of the First Amendment message of what's going on.
Right, actually, just the occupation itself.
Yeah, and the city's not giving you any reasons of what, maybe you think nothing good happens till after 10, but there's been some good political discussions there, There's stuff that is important to that group, and that's why I think, when Dick Kaiser was talking about, the city should sit down and say, hey, look, let's look at a set of rules that contemplate some political activities and what can we learn from this. But these rules here are not the result of thought out kind of information. I put in one of the legal arguments, but it's certainly, you can see how it works in this case. It wasn't even the city that, a city council mayor didn't discuss a 1030 rule. They gave Fred Gray or whoever's the parks guy, you can come up with rules. Well, maybe, the parks guy can come up with a lot of rules that might violate the First Amendment and the right to assembly. And we say that as applied, this violates the First Amendment and the assembly rights of these people.
Gotcha. Thank you. Okay, Alan?
Thank you, Your Honor. Your Honor, the fact of the matter is, whether Mr. Risner and his group like it or not, government may impose reasonable time, place, and manner restrictions on speech even in a public forum. The restrictions got to be content neutral, got to be narrowly tailored to servicing every governmental interest, and there have to be ample opportunity for alternative means of communication and information. We've heard no end of testimony here today about what went on in Armory Park and how they're followed on Facebook, and more to the point, the public forum, the sidewalks are always available. And you heard testimony here today that they actually left the park, stood on the sidewalk to avoid the citation. I submit to the court, if you want to be there 24 hours a day, then you walk the sidewalks. That's what better way. Wouldn't that get you on the news? Wouldn't your friends on Facebook be even more amazed to see at 3 o'clock in the morning a group of people parading around Diente de Agosto Park in support of this movement? So there is ample opportunity to do that and still work within the confines of the law. Our city code is content neutral, Judge, and therefore it's subject to less scrutiny. The city ordinance at issue is not enacted or was enacted or proposed because we disagreed with the defendant's message. This ordinance has been around for decades. It empowers the city to administer the parks for the good of all people. And throughout this testimony, I was struck today how this group and these people have decided that to put their interests before the interests of the general public and to substitute their judgment for the way the parks should be managed for the elected officials. And they've offered no evidence that they have any expertise in how to manage parks. So when the elected officials...
have a right to speak.
I'm sorry?
You have a right to speak.
Absolutely have a right to speak.
If I'm wrong, I think that there should be no government at all. I have the right to go out.
Absolutely, absolutely had that right. 16 and a half hours a day. You just can't do it in the park during the time the park is closed. So, the code's silent on the point of views expressed by the defendant, Your Honor. It's absolutely content neutral. Through Mr. Risner's pleadings, he mentions more than once that it never envisions political talk. That's exactly right. It's blind to politics. It's there to administer the parks for the good of the people and the citizens of Tucson. It applies to any park. And it applies to any person or group that are using the parks. So it's administered in an even-handed manner. As far as being narrowly tailored to a significant government interest, Your Honor, the regulations for the use of the public forum and assure the safety and convenience of the people are not inconsistent with civil liberties, but are one of the means of safeguarding the good order on which those civil liberties depend. That's from Thomas v. Chicago Park District, Your Honor. It's in our plea. I invite the court to read that. The government has a significant governmental interest in keeping these parks attractive and in intact condition, readily available to the people who wish to see and enjoy them by their presence. That's Clark for the communication of creating nonviolence. Again.
Do that. Does Clark talk about a time limit that they cut off?
As a matter of fact, they do, Your Honor.
Okay.
On the National Mall, they wanted to camp overnight. That was, prohibition against that was upheld in that very case.
I'll read on to Jesus.
This code does not burden more speech than is necessary. It only closes the park from 10:30 till the morning hour. At the night. The sidewalks, as I've said before, always available. So at least 2/3, a little more than 2/3 of every day, they can go there, they can protest, they can have their tents. I thought it was telling that we're insistent on 24-hour occupation, but yet when Ms. DeCamp was on the stand, she said there were only 2 of us in the park. So it seems to me, as Mr. Crow it seems to me that one of the witnesses said that these tents are props. It seems to me that an empty tent serves the same purpose. That's the case. But the point, more to the point, Your Honor, is the city has the right to regulate the parks.
Okay, so
And we've done that in a content-neutral fashion in accordance with the
I suppose that
Constitution.
ordinance and that these folks can put their tents, leave their tents at night, but not occupy the tents.
That's what they have done, Your Honor, whether or not we put them in.
Okay, I haven't visited, put signs all over. That's okay, right? Any expression of free speech can be.
They have done that in contravention of the law, Your Honor. It doesn't matter what I say here today.
They can't put their tents up.
They have put their tents up. They can't be in the park after 10:30. They can't camp in the
Right,
park.
they can put their tents up and you're,
And take them down, sure.
no, and they can put signs up all over.
Sure.
You just want them out by 10:30.
I don't want them out. That's what the city council wants.
That's what the Parks Director wants.
Well, the city council appointed the park director and delegated to him the authority.
The Koch brothers can put $100 million and buy TV time, and unlimited amount of money can go into this and that and that. But how do people without those funds, how can they be effective? You know, you've heard testimony how some kind of demonstrations, you've got signs, you try to do this, try to do that. This, for these people, this is effective. And they really don't have alternative means that are anywhere near as effective.
Isn't that just more or less their opinion that's effective? Do you have any statistics outside of the Facebook and the 1,000 or 100,000 tune in or something? Is that what's being effective? Is
No,
just getting to the people?
No, actually, there are statistics, and I had some testimony about that, of the level of contributions and involvement with the group. It is dramatically effective when they're not in a park where there's not a locus for the group. Having that locus and 24 occupation is effective and central to the whole message. That's you've seen that probably in the news, just in general knowledge from New York and other places. this Clark case is interesting. It was a 1984 opinion by Berger from the U.S. Supreme Court. This involved the mall in Washington, and they get a lot of demonstrations in the mall. So the Parks Department, in fact, has worked for years and has some rules and tailored stuff relating to the rules on the mall. And there was, this was creative nonviolence group, whatever it was, but they had an encampment on the mall with tents, and they had a permit, and they were allowed to be there 24 hours a day. They were allowed to be there at night. They weren't allowed to sleep in the tent. That was a park rule. And so what the Supreme Court said a couple things. One is they said, look, we assume that sleeping there is in fact symbolic speech. But we're going to approve the Park Service's ability to regulate it in this location because this is the national mall of the United States. We have foreign visitors coming in. We have the museums along the side. We've got this and we've got that going on. And so because of the very uniqueness to the nation of this one mall, we're going to uphold the regulation in spite of the fact that we agree that that sleeping is, we assume it's First Amendment symbolic speech. That's not Armory Park. That's not Pancho Villa Park. The Banco de Agosto Park isn't this unique central and national mall. And so the Clark case is certainly a case that we all have to live with. But that's what that case turned on. The D.C. Court of Appeals ruled in favor of sleeping there 24 hours. The Supreme Court changed, but the reason was because of the uniqueness of the mall. Thank you.
Okay. I will take it under advisement.